The 261st District Court is back in session.
All right, Mr. Soltero, you may proceed.
Thank you, Judge. Mr. Machuca, I want to move the timeline along to the beginning of this case. It's true, is it not, that Flow Sports hired the Burgess Law Firm on November 4, 2019?
Did we? I don't
Hey,
know.
well, if you don't know the specific date, I can refresh your recollection. If you could, Mr. Weisart, if you could call up Defendant's Exhibit 101, please. Mr. Machuca, you're Flow Sports representative in this case. Do you recognize Exhibit D101 as the invoice for December of 2019 from the Burgess Law Firm to Mr. Herdlow at Flow Sports?
I haven't seen this exhibit. I believe you, though. Looks like it.
Okay. Your Honor, we'd offer Defendants 101 into evidence.
Judge, no objection, but I would like the goose and gander rule to apply. The defendants have marked their attorney's fees attorney's eyes only, even though they're redacted. And so they've had 7 lawyers throughout this case, and we'd like to be able to introduce their fees as well.
Well, I don't even know if they're claiming attorney's fees yet. So can we cross that bridge when we get to it? You clearly are, right? So
Yes, Your Honor, we are.
I mean, I will remember the goose gander rule on Friday. But for now, I don't know that they even have a claim for attorney's fees that I need to worry about today. So we'll see. But is there any objection to 101 otherwise?
No, Your Honor.
101 is admitted. That's Defendants 101.
And Your Honor, we are making a claim for attorney's fees, both under TUTSA and under the Mr. Saylor's counterclaim. Mr. Machuca, do you see on November 4th that there's an entry in these bills reflecting some work done by the Burgess Law Firm on behalf of Flow Sports?
That is correct.
So we know that, at least as represented by these bills, as of that time, the Burgess Law Firm had been engaged, right?
Correct.
Okay, let's take this down, Mr. Weisbach, please. I will represent to you, Mr. Machuca, that Flow Sports filed this lawsuit, its original petition, on November 27th, 2019, with a timestamp of 3 p.m. Do you have any reason to dispute that?
I do not.
At that time, the only claim against my client, Mr. Saylor, was for breach of the non-competition agreement, right?
Correct.
And the other claim made was the tortious interference against Rockfin, right?
Correct.
All right, let's talk about December 18, 2019. This is a big day. On December 28th, Flow Sports, filed a supplement to its petition alleging for the first time trade secret violations under the Texas Uniform Trade Secrets Act against both Mr. Saylor and Rockfin, correct?
Yes.
And in fact, you signed a declaration that day that was the basis for the TRO that Flow Sports got against my client and against Rockfin. True?
True.
Okay. I'd like to go over that declaration with you. I'm going to pull up, Mr. Wisrod, if you could please pull up Defendant's Exhibit 22. And in particular, blow up Section 4. Well, first of all,
don't blow it up yet. Let's not have him testify about it until it's been admitted. Is there any objection to Defendant 22?
No, Your Honor.
It's admitted. All right, now you can blow it up and ask him about it.
yes, Your Honor. Number 4. Okay. In this paragraph, you mentioned that in 2014, Flow Sports had a Series A funding round, that the PIIA or agreement was signed, and you go on and describe it a little bit, and then you say that the Flow Sports awarded Mr. Saylor stock options in connection with the Series A financing, right?
Yes.
Now, you can agree and admit that he did not get stock options in 2014, right?
That's correct.
At the time Mr. Saylor signed the PIIA, he received no bonus, no promotion, no additional compensation, no stock options, nothing, right?
No, not right.
At the time he signed this agreement, did he receive a promotion?
I'm not sure when he was promoted to senior editor.
Judge, I'm going to object to relevance. This is a non-compete. The trade secret, I mean, the confidential information is the consideration. It's not money, or a bonus or a promotion wouldn't even be a proper consideration. So it's completely irrelevant.
Your Honor, we have one of our arguments is inadequate consideration, and they gave him nothing at the time. He had access to confidential information beforehand, and then years later, they gave him stock options as part of his compensation. So we believe there's been inadequate consideration even under Sheshnoff in those cases.
That,
All right, go ahead.
Those aren't elements of consideration. I'm sorry, you're saying go ahead.
I was about to rule. You wanted to add some argument. I'm letting you add your argument.
Yes, even if we promoted him, gave him money, any of that would be improper consideration. His continued access to Periscope and the other items is what Sheshnoff says is the proper consideration.
All right. The objection to this line of questioning has to do with relevance. I'm going to overrule the relevance objection. Mr. Sotero, you may proceed, but do stay focused if you would.
Yes, Your Honor. We can take this portion down, Mr. Wisrod. So, Mr. Machuca, there was no bonus paid to Mr. Saylor at the time he signed the PIIA in 2014, right?
That is, to the best of my knowledge, correct, yes.
He wasn't promoted at the time he signed this in 2014, correct?
I'm not sure about that. I would believe you if you said no. I'd believe you if you said yes. I can't remember when he was promoted to senior editor at Resident.
Okay. And you would admit that for at least 2 years or some period of time before he signed the PIIA, Mr. Saylor had been working at Flow Sports and received the same confidential information privy to all types of business decisions without having a PIIA or other non-compete. True?
Yes.
Okay. All right, let's go, Mr. Wisrod, back to 22 in paragraph 6. And Mr. Wisrod, just to give you a heads up, I'm going to defendant 17 after this. So in here, in your affidavit, Mr. Machuca, or declaration, you say that Flow Sports, all close to the bottom line there, Flow Sports even permitted him to move home to Pennsylvania. Did I read that correctly?
You did.
Okay, and built a studio in his house, right? That's what you told the court.
That is what I told the court, yes.
Okay. All Flow Sports provided was equipment. They didn't build a studio, a physical thing. Isn't that true?
I mean, I like my use of the word built.
Mr. Wisrod, if we could go to Defendant's Exhibit 17, I'm not sure if this has already been admitted or not, but if not, I would have him review it and then move for admission.
Any objection to Defendant's Exhibit number 17?
No objection, Judge.
All right, so it's listed on the defendant's trial exhibit list as studio equipment. I just want the record to reflect that this is a photograph. It is not any actual equipment, so our record is clear. It's just a photograph. And the photograph of the studio equipment is admitted as defendant's exhibit number 17.
Mr. Machuca, when you say that you, quote, built Mr. Saylor a studio, this is what you're talking about, right?
What? I'm not sure what you're talking about, Mr. Sotero.
The equipment, the microphone, the headphones, the stand, etc.
Well, I want to be specific. I know you're going to ask me a follow-up question. Not the skull or the pork rinds, but the studio equipment. And I sent someone up there to set it up for him.
But there's no physical space. It was just equipment.
Correct, sir.
Okay. And after he left, he returned that equipment.
I would have an issue. I have an issue with you saying he returned that equipment very cavalier, like it was like in the box the same day. I'm not even sure we've received all the equipment yet.
Are you aware, as you sit here today, of any of the equipment that hasn't been returned?
Yes.
What?
Well, this isn't. I have one of my production manager has mentioned. I think we have this equipment still outstanding. It was like some ancillary cameras.
Have you ever made a request for that?
Hearsay.
Stained, but it's a little bit untimely, Mr. Brudica. You might want to leave your microphone off mute unless we get an echo from you in case you need to more quickly make your objection, although this one was kind of anticipated when he started talking about his manager telling him something. But in any event, Mr. Soltero?
Yes, Your Honor. Mr. Saylor returned the equipment that he had to Flow Sports in either November or December of 2019, right?
Mr. Saylor has returned equipment to us either in November or December, yes.
Okay. And this lawsuit isn't about these 2 cameras that you're now bringing up, is it?
No, I'll only bring them up not to be argumentative, but to add character to the answer.
Okay, let's
You
go,
asked me
Mr.
if
Weisbrot.
Without question, I was like, well, actually, there's a couple other items, but I'm not making an issue of it, no.
Okay, Mr. Weisbrot, if we could go back to the declaration, paragraph 7. The second page. So in here, you tell the court about access that Mr. Saylor has been granted. You know at this time that Mr. Saylor doesn't have access to Stripe or Chartbeat, correct?
Correct.
Okay. Going on to the next paragraph, paragraph 8. In here, you describe some of the features of Periscope, true?
True.
And while he may have access that while he was there, with the one exception we know about, the day he was looking at his attribution for bonuses, as he says, you knew by December 18th that he had no access to any of this information, correct?
Correct.
Okay, then we go to paragraph 9. Okay, you say Mr. Saylor quit his job at the end of October 2019. That's not exactly right, but I'm not going to fuss with you. We can agree it was November 2nd, right?
Yes, sir.
Okay. And then when you say he tweeted out confidential salary information he gained at Flow Sports, I want to focus on that part. The sole basis in this case that Flow Sports rests its case on is the one tweet involving Ben Askren, correct?
No. The
Okay.
sole tweet we rest our entire case on.
No.
We have competition,
Let me be very clear.
Yes, sir.
With regards to your disclosure of confidential salary information, the sole basis for that claim is the tweet involving Ben Askren, true?
No.
Okay. Well, let's talk about that one. Well, what other salary information are you contending that he's ever tweeted out?
Around Thanksgiving, this is going to be objected to. Should I keep? I don't know.
Well, no. Let me state it again. I mean, let me rephrase it this way. Have y'all ever disclosed to us any other basis for complaining about confidential salary information other than the Ben Askren tweet?
I'm going to object that have you ever disclosed, he's not bringing up a particular, any kind of discovery request. I mean, he's asking this witness everything that happened in the litigation, and that doesn't seem fair.
I don't understand the legal objection to the question.
Sure, that it's overly broad and it doesn't ask a question that this witness can answer.
Overruled. If he doesn't know the answer, he can tell us he doesn't know the answer.
So I believe I mentioned this in my deposition. I can't recall precisely, but when we were discussing about the lawsuit, whether or not around Thanksgiving, I remember very vividly, I was at my parents-in-law's and Christian Piles shared with me a text exchange where Willie said, I would do more of it. I would put more of this out there if you don't drop the lawsuit.
Okay. But in fact, Mr. Saylor did not tweet out any other, what you call confidential salary information other than this Ben Askren tweet, correct?
Other than the tweet and other than the ongoing threat, no.
Okay, and the thread is this text is part of the chain between Mr. Piles and Saylor, their communications, right?
Yes, sir.
Which was not public.
That is true.
Okay, so back to my original question, the sole basis for disclosing confidential salary information is the Ben Askren tweet, correct?
No, not correct. I'm telling you that he threatened us to Christian Piles. And so, I mean, I don't know why you want me to not take that seriously.
Whatever that threat.
Let me try. I think there's a disconnect. I think what he's asking you, Mr. Machuca, is whether or not you have any evidence that he actually did it. Not that he threatened, not that he talked about it in an email just to your employees and so forth, but whether or not there's any evidence that you have to offer today that would suggest that he either made good on that threat by actually doing it. I think that's what he's really getting at. And if that's correct, Mr. Soltero can confirm that. If that's not, he can tell us that that's not. But that's how I'm hearing it. And I think you're answering the question slightly differently. So I there's a disconnect, and I'd like us to get on the same page. So I'm going to ask Mr. Soltero to try once again to sort of clearly articulate his question and answer just that question, if you would. Go ahead, Mr. Soltero.
Yes, Your Honor, that's absolutely correct. I'm just asking you whether there's anything that Flow Sports contends Mr. Saylor actually, quote, made good on a threat or tweeted anything else other than that one Ben Askren tweet that we're about to talk about.
That's correct.
What's correct?
That the one thing that he's done, well, I guess I'm not sure how to characterize this, but the why I left Flow video, when he goes on and talks about this is what Flow does, this is what I'm going to do. That is, they don't say these things for these reasons. I will not do that. I'm going to be different over here. That is also him espousing information he knows is confidential, that we don't want to be putting that out there, in addition to the tweet.
Mr. Machuca, you swore to this court and obtained a temporary restraining order against my client and then an injunction on the idea that he had tweeted out confidential salary information. My question is this: as we sit here today, over a year later, has he, not since December 2019, but since he left, has he tweeted out any other confidential salary information other than the Ben Askren tweet?
Salary information, no.
Okay, and that's the basis of the non-disclosure claim that Flow Sports has brought against Mr. Saylor, right?
No.
Okay, all right, we'll come back to that. But let's go to the Ben Askren tweet. Let's go to F810, please. It's already been admitted into evidence.
Oh, don't put it up, Mr. Weisrott. We admitted the redacted one. I mean, we only showed the redacted one. The other one is the subject of a temporary sealing motion and are agreed. We don't want to
810 is has been admitted as an unredacted tweet. If
it was admitted subject to the temporary sealing order. We have to get them admitted before we can get the sealing order over them.
And Judge, before Mr. Weisrott, before you put it up, Judge, under 3AI of the protective order, something that's been publicly disclosed cannot be attorney's eyes only. It's a tweet. It's already been made public.
But it was taken down.
I have 810 as having been admitted as an unredacted tweet by Mr. Saylor. So we can check in with the court reporter, although we have two court reporters. I'm not sure without looking back at my notes, what part of the on Friday this evidence came in. I'll have to go check with them. So let's do it at a break. I don't think that the subject matter of the tweet is something that has to be displayed and live streamed at the moment. Everybody's familiar with it. The witness has a copy of it, as do the rest of us. So I think we can ask them questions about it without displaying it on the screen. And we'll come back to whether there were any conditions. In my notes from Friday, I have 810, plaintiff's 810 unredacted tweet of Mr. Saylor's as being admitted. But as I said,
And
we
I
don't
think
need to display it at the moment. I do recall Ms. Burgess making some comments about it, but for our purposes at the moment, it's not necessary for us to fuss about it. Let's just
Yes,
ask.
Your Honor.
Not a copy of it. Let's just ask him a question about it.
Yes, Your
ahead.
Honor. So, Mr. Machuca, you know that there was no numbers included in that tweet, correct?
That's correct.
There was no details other than a general comparison of what apparently Ben Askren may be getting compared to other people on Flow staff. Is that right?
I wouldn't characterize it that way. I would characterize it as an ex-senior member on the content team who quit, had deleted content, had done all this sort of stuff, and was now leveraging information that he knew with the intention of causing harm to the team. And
Your Honor, I would move to strike, and he's non-responsive.
Sustained. Mr. Machuca, he's just asking you, I think, fairly simply about what was included or what was not included, not what you think the motivation might have been. I appreciate you have an opinion about that, but that's not actually his question. His question was about what it actually says or does not say, and I'm going to ask him to re-ask his question so you're clear about what you're to answer. Mr. Saltero?
Yes, Your Honor. Mr. Machuca, all that was tweeted was a comparison of what Mr. Askren was going to get on a monthly basis versus what other people on the staff might be getting paid. Is that right?
so the issue I'm having, Mr. Soltero, is when you say all that was tweeted, is when you say all that is tweeted, that the connotation and denotation of that word is meant to minimize it and not make it like a big deal. And I'm telling you that you're right. He tweeted that out. That is true. But it wasn't all it was.
So, Mr. Machuca, please understand the question in reference to exhibit number 810 offered and admitted by the plaintiff. He's not asking you about every single tweet ever. He's asking about that one.
Yes,
so the
ma'am.
question is about exhibit number 810, Flow Sports exhibit, okay? Not every tweet, just that one. So what's the answer with regard to his question about 810?
That is the tweet that Mr. Saylor sent.
Okay, Mr. Weisrod, if you could put paragraph 13 of defendant's exhibit 22, the declaration up. I'm going to skip a few paragraphs for now. It's on the third page. In this declaration, you swore that Mr. Saylor had gained 5,000 Rockfin subscribers, right?
Correct.
That's not true, is it? Let me come at it a different way. You had no personal knowledge of the amount of subscribers that he actually had. True?
Just looking at Rockfin platform.
That's not my question. But what you're saying is that you went onto a website and you interpreted whatever was on Rockfin's website, and you then said that this was the case, right?
True. I interpreted the data and made a decision.
But you had no personal knowledge of the facts about how many actual subscribers he had, right?
I have not been made available all the Rockfin data, no.
Okay, and you didn't at that time. And do you know that, as a matter of fact, he doesn't even have 5,000 subscribers now?
I don't know that.
You just don't know.
I know
Right.
just looking at Rockfin, that's all I know.
And subscribers are not the same things as followers. Is that right?
Depends on who you're talking about.
A subscriber is not a follower necessarily. A subscriber could be a follower, but you can be a follower without being a subscriber. True?
Necessarily is the key word there. Yes.
Paragraph 10 of the declaration, you say, from the Flow Sports computer Mr. Saylor used, we can see that Rockfin had been trying to recruit him, etc. By this time, you had Mr. Saylor's computer, right?
Correct.
Did you personally, Mr. Machuca, look at his computer?
No.
Okay. All right. Let's get rid of the declaration for now. We can agree, can we not, Mr. Machuca, that rankings are public?
Sure.
Okay. And therefore not a trade secret, correct?
Sure.
And we can agree that you're unaware of a single formula that Saylor or Rockfin have that belongs to Flow Sports, right?
That is correct.
And you're not aware of a single algorithm that Saylor or Rockfin have that belongs to Flow Sports.
That is correct.
And before Mr. Saylor went to Flow Sports, he had been writing about wrestling and doing ranking, true?
Absolutely.
And he did that based on public information.
True.
No algorithm tells Mr. Saylor how to rank people, right?
Correct.
And is it Flow Sports' position that if Mr. Saylor has kept newspaper articles of old wrestling rankings, that that's somehow Flow Sports trade secrets?
No.
Okay. By the time Mr. Saylor left in 2019, he had not been a manager for some time, correct?
I don't know what you mean by sometime. If we're friends now, sure. I would agree.
I don't know what you mean by if we're friends, but let me be very clear.
I mean, like, if you're just asking me generally, sometime sounds fine.
No. I want to be real precise, Mr. Machuca. When did Mr. Saylor cease being a manager at Flow Sports?
Then I don't know, because you said sometime. I said, well, you're asking me if we're just talking, yes, but now if you want to get precise, I don't know.
When did he move to Pennsylvania? I'm sorry, Your Honor.
Excuse me, Mr. Machuca, he's past that, if you will, and is asking you a fresh question about when something occurred, if you know. So that's his question. He wants to know when Mr. Saylor stopped being a manager, if you know.
I don't know, Your Honor.
When he moved to Pennsylvania, was he still a manager?
He was not.
Okay. Was there a period of time while he was still in Austin before he went to Pennsylvania that he was not a manager?
I'm actually not sure.
Okay.
Yeah.
So do you still agree today, like you did when I asked you about a year ago, that an overwhelming or core part of Flow Sports business is the video streaming of live events?
It is.
I'm going to object to the improper impeachment. This goes back to a deposition, and he used two different descriptors, and I don't know.
So
It sounds like
I got it. Mr. Soltero, what's confusing for me, frankly, is if you're asking him generally about things he remembers from the deposition or a specific statement. So in fairness to the witness, if you could be clear whether we had this problem when Mr. Brudicow was asking questions. Generally, does he remember things? I don't have any problem with that. You don't have to show him that. But if you want to ask him specifically about a statement, you have to show it to him.
Yes, Your Honor, I understand. So, Mr. Machuca, is it still true today, as it was in December of 2019, that an overwhelming part of Flow Sports business is video streaming of live events?
same objection, Judge. If he's quoting something and saying, is it still true today? We need to get a chance.
I don't know whether he's quoting or not, but the suggestion that something was still true before sounds like your testimony, Mr. Soltero, not his. So if you can ask him if he took that position then and if he still takes that position today, but in your question as a reference, it sounds like testimony you're offering, which of course would not be appropriate.
Sure. Isn't it true, Mr. Machuca, that you testified before this court that the core part of Flow Sports business is the video streaming of live events? The overwhelming part.
That is still it's an out-of-court statement, and he's quoting it and asking him if he testified to that. That's impeachment, and it's not.
I'm setting him up for impeachment, Your Honor.
He's just trying to pin him down, frankly, to if we're going to use law school. If we're going to go back to law school here, he's just trying to pin him down to find out if that's his position or not. I don't think that's improper. You can answer that question. Did you tell me that when you were either in your declaration or in your live testimony at the TI hearing or any other court proceeding? Did you say that or not? Was that your position or not? This is not a trick question, Mr. Machuca, and I don't want you to think anybody's trying to trick you. Simply, Mr. Soltero was trying to appreciate whether or not that was the position of Flow Sports at the time and whether that's still their position. It's really that simple. Is it or not?
It is a core part. Your Honor, I remember me going at length trying to broaden the difference between Flow Sports and say, I know they're a broadcaster that just streams live events. I said that Friday in my hearing that it is like cake. You can't really take them apart. That is what makes Flow Sports so valuable. I know Rockfin knows that just as well as anybody. And so, yes, there's, I also said I speak for, I'm 30%, my department is 30% of the company, 17% of the OpEx. It's one and the same. It's a complicated business. That's what makes it valuable.
Objection, non-responsive.
Yeah, let's do it this way. Mr. Machuca, you remember that you testified before the court at the temporary injunction hearing live on the stand, and I cross-examined you, correct?
I remember.
Okay, if I can share the screen, I'm going to show you a portion of that transcript now. Beginning on page 110, and you fought me then too.
Mr.
I said-
Soltero, please avoid making sidebar comments.
Yes, Your Honor. I started by saying the key business of Flow Sports is video stream of live sporting events, true or false? Well, I guess I don't know what you mean by key business. And then I said the core of your business. And again, you said, and then I said, does Flow Sport as a business, are you corporate representative for, is their business model to video stream live events? And on page 111, you said that's part of the business. I said, is it an overwhelming part of your business? It's what you're known for. And you said, uh-huh. And I said, yes. And you said, yes. That was your testimony then, correct?
That is something we're known for, yes.
Okay. And that's still true.
We are still known for that, yes.
Okay. By contrast, what makes Willie valuable is his brain. You don't need to look at Ms. Burgess. Just answer my question, please, sir.
I didn't hear a question, sir.
Oh, I said what makes Willie valuable by contrast is his brain.
That sounded like a statement.
Do you agree or not agree?
Do I agree with your statement?
Yes.
Yeah, I'd agree with your statement.
Okay. And that's something that Flow Sports doesn't have a right to control, correct?
That is correct.
Okay. Let's go back to the on paragraph 11 of the declaration. You also talked about, or you testified rather, about Mr. Saylor continuing to access confidential information from Periscope after he quit. Is that what that declaration said?
Yes.
And allegedly that he took 175 screenshots from his Flow Sports computer, right?
Right.
After he quit.
Yes.
And that he exported 69 ranking sheets, you said, right?
Yes.
Okay. Did you do that investigation or know the specifics about that?
Well, there's two questions there. I didn't do the investigation. No, sir. I was made aware through counsel the specifics around that.
So you have no personal knowledge of that, right? Just what counsel told you?
No, just from talking to legal counsel who talked to experts. Yes, sir.
Okay. And have you ever looked at the 175 screenshots that were eventually produced to us in September of 2020?
Yes.
Okay. You'd agree that that includes publicly available information, it includes tweets, it includes cell phone numbers, right?
Yes.
Okay. Flow Sports does not contend that's trade secret information, does it?
Well, it depends. Like the phone numbers would be our stuff, but the if it's a screenshot of his mom, I don't think so. No, sir.
Okay. And you don't know whether, in fact, Mr. Saylor took these screenshots after he left or whether somebody else took those screenshots, correct? You don't know that.
I guess in just all I know is from our experts in legal counsel. I know.
Okay. And to be clear and leave no mistake, as Flow Sports corporate representative, Flow Sports has no evidence that Willie Saylor exported 175 screenshots off his laptop, right?
Judge, they can't ask him questions as a corporate rep and then ask him to have personal knowledge of every single item that he's talking about. If they're asking it, they ask him about texts between other people. It's improper to say that Flow Sports has no personal knowledge because one person's head doesn't have personal knowledge.
His question specifically was whether or not Flow Sports had any evidence. So the objection is overruled, but in fairness to Mr. Machuca, now that we've gone back and forth, Mr. Soltero, if you could re-ask him your question, please, so Ms. Burgess is clear and he's clear what you're asking.
Yes, Your Honor. And I would also give Ms. Burgess the courtesy of letting her know that we're on page 27, lines 13 through 18 of his deposition as a corporate representative. My question, sir, is Mr. Machuca, as Flow Sports corporate representative, yes or no? Does Flow Sports have any evidence that Willie Saylor exported 175 screenshots off his laptop?
Again, this is improper impeachment.
I don't think it is, Judge. He's the corporate representative.
I think the question is just, I can't tell Mr. Sotero if you're asking him to confirm that that's what he testified to or if that's what his testimony is today. So perhaps you could clear that up.
Yes, Your Honor, I will. And Mr. Weisreich, you can take this down and if you could queue up impeachment video clip 2 if necessary. Mr. Machuca, you testified on September 21, 2020 as a corporate representative in this very proceeding that you had, as Flow Sports, no evidence that Willie Saylor exported 175 screenshots off his laptop. True?
True.
Similarly, you testified that as of September 21st, 2020, Flow Sports had no evidence that Mr. Saylor had exported 69 ranking spreadsheets off of that laptop that it seized sometime in November 2019. True?
The only evidence I had was from our corporate rep and corporate,
Well, hold on. I need to object for optional completeness and legalities. We sent a brief in on this, Judge, this morning.
I love how you expect me to have been well versed on it this morning. So look, let me stop you there. If you all want to talk about this at the lunch break, I'm happy to give up my lunch break to talk to you about it. But in fairness, when you send me a brief, at 8 o'clock Sunday night or anytime Monday morning, right before we start our trial, you can be assured it's likely that I've not had a chance to digest it. So
I understand, Judge, but
I don't know what's in. Let me finish, please. I don't know what's in your brief. I don't know that I need to read it for us to get through the rest of Mr. Machuca's testimony. But if you need to, we can take it up at the break. Mr. Soltero's question, I think, is something that doesn't require briefing. But if necessary, I'm happy to talk to you about it at a break. So, Mr. Solt, the last question, I believe, is a question about whether or not Flow Sports has any evidence that he exported rankings or anything else. And the answer was about to be what somebody at the company told Mr. Machuca before the objection. So, Mr. Soltero,
Yes.
Ms. Burgess's ability to argue about whatever she wants to bring up over the break. Is there some other place we can go to finish up his testimony, or and then come back to this after we've had a chance to talk about it in chambers or wherever?
Yes, Your Honor. That's fine. I'll move for now off of this so we can,
Or we could just take that, do that now. It's fine with me. I haven't read the brief is all. And so if you want me to look at a brief before I tackle this issue, that has to happen at the break. If you want me to just hear argument now, I'm happy to hear argument now. It's really up to Ms. Burgess. I don't want to be disrespectful to whatever effort went into preparing a brief, but I have not read it.
well, Your Honor, I've been here questioning witnesses and preparing, so I haven't had a chance to look at the brief.
Right, so I'm just
Right,
saying,
Judge,
we can talk about it now without the benefit of the brief, or we can all take a look at the brief and talk about it over the lunch break. One or the other, doesn't matter to me.
I would
ask
prefer
that
the
we
lunch
do
break.
latter. Right,
I'm sorry.
over the lunch break would be better.
Okay, great. Then let's move on to another topic and we'll come back to this one.
Okay. Back on our timeline, Mr. Machuca, you know that Flow Sports sent a private investigator to Mr. Saylor's house in Pennsylvania on November 13th, right?
That's correct.
And they picked up his laptop at that time.
Correct.
I'm sorry?
Correct. Yes, sir.
Then Flow Sports hired a forensic expert that's really well known here in Austin, well regarded, R3, to do an investigation of his laptop, right?
Correct.
You initially designated him as a testifying expert, and we had a hearing with this court, right, in February?
Correct.
And after that, Flow Sports de-designated R3 as and called him a consulting expert. Isn't that true?
True.
And
I'm not.
Flow Sports
can't-
also hired an Austin lawyer named Jason Snell to also go through Mr. Saylor's information, correct?
On the previous question, I didn't answer it. I'm not sure about the designation on R3. We did
Okay.
hire Jason, yes.
Okay. Well, you are aware that the report that R3 produced or whatever has never been made available to our side, right?
I wasn't aware.
I'm gonna object in
He
the,
doesn't know the answer, so let's move on.
Yes. In fact, Mr. Snell, there were Gmails that were accessed of Mr. Saylor's personal and private emails while that computer was in Flow Sports custody. True?
Was it?
I'm gonna object to relevance, Judge, that Judge Jenkins granted us summary judgment on the Electronically Stored Communications Act. So this doesn't go to anything.
Your Honor, may I respond?
Please.
One, it goes to the issue of the inequitable conduct. It goes to the way that they've responded to things. And so, yeah, I think it goes to our claim for attorney's fees on the bad faith trade secret case.
All right.
We-
Go ahead.
Judge, you've ruled many times in this case that computer belonged to Flow Sports. We merely went and secured our computer, and Jason Snell was the team that reviewed so that we wouldn't accidentally see anything that was potentially privileged.
That's not inconsistent with Mr. Sotero's question. Look, here's the basic way to view this from my perspective. One party is claiming that the other party inappropriately accessed information and then disclosed it to people they didn't have any business disclosing it to. So that's at the heart of the dispute here. So I'm having difficulty understanding why inquiries into what was accessed, when it was accessed, by whom it was accessed, and what they did with it is being somehow irrelevant. So for that reason, the objection is overruled. And so, Mr. Soltero, you have the floor. You may proceed.
Yes, Your Honor. Mr. Weisrod, Defendant's Exhibit 89, please. And then 90 is coming right after it. Um,
Uh-oh.
Mr. Machuca, do you recognize Defendant's Exhibit 89 as one of the screenshots and exhibits that Flow Sports used at the temporary injunction hearing?
Yes, sir. I believe it. Yes, sir.
Okay. Your Honor, we'd offer Defendant's 89 into evidence.
No objection.
Admit it.
So, Mr. Machuca, you see that this is, if you look at the tab up top, it says Smalls 103, right?
Mhm.
That's Mr. Saylor's address, right?
Yeah, I believe it is. Yes, sir.
And this is a screenshot that y'all took and that you brought to the court, right?
I don't know.
Not you personally, but somebody at Flow Sports.
I'm not sure if this was in the battery of exhibits but I believe you. That's what's being said.
Okay. And we can see here that there are 306 Gmails that are in the queue, so to speak, at least in the inbox. Do you see that where it says 278 of 306? Or is that pages of emails? Do you know?
I'm not sure what you're looking at, sir.
Right there, what's been highlighted by Mr. Wisrod.
The yellow highlight to the right.
Oh,
It's under Ruth Bader Ginsburg.
sorry.
there's a
278 of 306. Yes, sir. I see it now.
Okay. And in addition, let's go now to Defendant's 90. Do you recognize this also as something that was produced in connection with whatever was done to Mr. Saylor's computer?
Yes.
Okay. We'd offer Defendant's 90 into evidence.
No objection.
90 is admitted also.
Mr. Wisrod, if you could highlight the box that shows that there's a search being conducted. Mr. Machuca, you recognize that what's happening here is that somebody is conducting a search, in particular of Martin at rockfin.com, through all of the emails that are on Mr. Saylor's personal Gmail, correct?
That is what's happening. Yes.
And you know, because we can take the exhibit down, we know that because that's what Flow Sports authorized, for somebody to go through Mr. Saylor's personal Gmails.
I wouldn't characterize it that way.
Well, you also went through his iChats, right? Not you, Flow Sports.
Our forensics expert. Yes.
Okay, and that included communications with a lawyer named John Reenan, who made an appearance in this case, right?
If you say it did, sir. Yes.
All right, let's go back to what y'all contend your trade secrets are.
Judge, I think it's important to note here that that's what Jason Snell called for, so that there was nobody's alleging that we saw attorney-client communications, just so that you know.
I don't know what that relates to in terms of the questions Mr. Soltero is asking. So let's just move to his next question.
Let's go to, isn't it true that in response to a court order disclosing what the trade secrets are, Flow Sports did not include the spreadsheets?
Did we?
Do you have, I'm going to object that if there's a document, a disclosure, that we should be able to see it before he's.
Your Honor, may I ask that counsel not get in the middle of questioning? If he doesn't know, he can say he doesn't know, and I'll
Yeah,
approach.
She has made an objection, and frankly, I think the spreadsheets is just a little bit vague. So perhaps you could clarify what you mean, either by reference to an exhibit or in some other way that might help the witness understand what spreadsheets you're talking about.
Sure.
And
Yes,
also,
Your Honor.
I
We'll
would
go
ask
to,
that
let's,
the discovery response is supplemented, that the supplement be included.
He can offer or point to whatever he wants, Ms. Burgess. It's his cross-examination. So if you have an objection, you can state it. I've sustained the one you've made with regard to vagueness because it's vague to me. So he's going to now clarify what he means by the spreadsheets if he chooses to.
Okay. Mr. Machuca, if you could turn to, or actually Mr. Wisbrot, if you could pull up Defendant's Exhibit 162.
And Judge, this, I object to this exhibit. It was supplemented on September 20th,
Ms.
2020.
Burgess, you're premature. He hadn't done anything with it except ask that it be displayed to ask the witness a question about it. So hold on a minute. Let's see what his next question is or next request to the court might be. And once he makes it, then you can object if you have an objection. Right now, I don't know what the question is that you're objecting to. Mr. Soltero.
Yes, Your Honor. I would offer Defendant's 162 into evidence.
Ms. Burgess?
And I object, just like pleadings, when they're supplemented, they're not, the previous answer is not relevant.
So are you telling me that 162, the document, what is this anyway? Your interrogatory answer has been amended in some way or supplemented?
Yes, Your Honor. After the defendants gave us the spreadsheets on September 16th, then it was supplemented on September 20th.
And Your Honor, I thought we were going to do this in chambers, but counsel represented to us that they were not claiming that the spreadsheets were going to be an alleged trade secret. But apparently their case totally changed after some additional production of something that had already been produced to them.
That was not represented.
Well,
And
I don't know what you represented when or to whom or what conversations you all may have had. The issue on the table at the moment is whether or not this is a relevant document because it has been supplemented in some way, not amended, but supplemented is what I'm being told.
I think it was amended, but I don't have the
Well, that's
other
different.
document.
Supplementation and
Amended.
amendment are two different things,
It was
right?
amended.
Supplement meaning supplanted. Amended meaning revised in some way. So which is it? Was it amended to create some difference in what we have here in 162 or supplemented? Either one is fine. I just don't understand what you're telling me. Was the answer to whatever's happening in 162 here completely a different answer, or was the answer just supplemented or amended in some way to create some tweak, if you will, to the prior
It
answer?
was supplanted by 165 by amendment.
All right, so Mr. Soltero, the objection to 162 is essentially that it is not relevant because they don't stand by that answer and don't intend to because they changed that answer in 165. So what, any argument do you have that?
Well, Your Honor, for starters, I'd say Defendant's 165 says Plaintiff's Flow Sports second supplemental objection and answer to Defendant Willie Saylor's interrogatory number 2, which is what the court had ordered them to do in February, which they did in Defendant's Exhibit 162, did so again in 163 and 165, supplemented but did not amend. And so I think all three are relevant, none of which mention the spreadsheets, which is the point I'm making.
Does 165 mention the spreadsheet?
I don't believe it does.
Well, in which case that answer also, excuse me, that answer also plays into your theory of the case, correct? And so we don't really need 162, 164, and 165. That would be redundant, wouldn't it? And so won't 165 suffice since that's the one that they stand on?
Your
I
Honor,
agree on that.
I have an answer, but I'd like Mr. Brutico to speak.
Sure.
I mean, it goes to the credibility of the plaintiff if they are constantly supplementing and changing their responses to this fundamental question. So I think it goes to credibility, Your Honor. I don't think that it's duplicative.
Yeah, I disagree. They're allowed to supplement. They're allowed to amend. That doesn't speak to credibility necessarily. It might, depending on what they changed and why, but there's no evidence that that's there's something nefarious there. It's just that they, under the rules, were allowed to amend or supplement, which is what they did. The question here is whether or not 162 is relevant because it was either amended or supplemented. We seem to be using those terms interchangeably, even though I think they're different. But in any event, if the answer that Mr. Soltero is really trying to make his point about is that it's not the subject of something contained in 165 and it's not in 162, then there's a little consequence of what else was different about it. That's the point he's trying to make, and that's demonstrated by 165. So if you want to offer that one, you can, but the relevance objection to 162 is sustained.
Right. Okay. Your Honor, we'll come back to 165.
Well,
Let's
just so
move to.
excuse me, just so the court reporter's record is clear, 162 has been offered, but it is not admitted. The objection to it is sustained.
Okay. Let's talk about monikers and catchphrases, Mr. Machuca. You agree that Crystal Ball Rankings was not created at Flow Sports, correct?
Correct.
And did you watch last week Steve Karnacki on Big Board during the election?
No, sir, I did not.
Okay, but you agree with me that the term Big Board was not a moniker created by Flow Sports, correct?
That is correct.
And Stock Report is not something that was created by Flow Sports?
That is correct.
Match Notes is not something that was created at Flow Sports?
I don't think it was.
And Duck SCN was also not created at Flow Sports.
No, sir.
Okay. It's also true that ESPN and others use the term who's number one, even though y'all have a specific use that you use for it, right?
Yes, sir. Like other entities use these words in the wrestling community. We've made them prominent, sufficiently so.
Since Mr. Saylor left, Flow Sports has not used the phrase greatest mind in wrestling. Is that right?
I don't think it has.
Mr. Saylor was an at-will employee,
True.
and Flow Sports had both the ability and has done on occasion of actually put somebody on a term contract basis, right?
Yes, sir.
But it chose to, for whatever reason, not to get a term contract with Mr. Saylor, right?
That's correct.
So he could have left for any reason, and you could have terminated him for any reason.
That's correct.
Prior to suing Mr. Saylor, it's true that Flow Sports did not send him a demand letter or presenting anything, including attorney's fees, prior to the suit. True?
True.
Flow Sports has lost no live events because of Willie Saylor's conduct, correct?
I think it has. I think we're competing over time events, and we've lost
So,
some.
Mr. Wisrod, if you could queue up impeachment video number 3. And what I would ask is, let me ask you again to make sure I got confirmation of what your sworn testimony is and what it was before. Mr. Machuca, on September 21st, 2020, when you were the corporate representative of Flow Sports, on page 35, line 10 through line 14, I said, I'm asking for something slightly different, which is, as a factual matter, there have been no live events that Flow Sports has lost because of Willie Saylor, correct? And yet that time you said correct. Isn't that true?
First of all, it's improper impeachment. Second of all, Mr. Saylor's deposition had not yet taken place.
Also,
I don't understand what Mr. Saylor's deposition has to do with Mr. Machuca's deposition. So to the extent that that's some sort of an objection, it's overruled. The question, and all the objections at the moment are overruled. The question is simply whether or not he read that part of your deposition correctly.
I can't be sure, Mr. Soltero. I thought I went on to add that we've definitely lost events.
And Your Honor, because we're over Zoom, it's a little more cumbersome, but what I would request is that Mr. Wisrot be allowed to play a short video, about 20 seconds, 30 seconds, of exactly this page and line that I've just quoted.
I would need to, I'm sorry, I would need a moment to check on optional completeness before something is played over the internet from the deposition.
Your Honor, I think that Ms. Burgess will have plenty of opportunity to redirect Mr. Machuca however she wants. I'm just trying to complete the impeachment, and he's fighting me on it.
Optional completeness happens in the moment, not tomorrow. So she
Sure.
has an opportunity to review optional completeness for the information for that purpose and then offer it at the time you offer what you're offering. So that's something we can take up at the break as well, which we're going to have shortly. So you can take a look at that and figure out if there's more you want to do it. But for purposes of the next question, Mr. Sotero, you may proceed.
Hey, Judge, I think I will say I understand, and I'm going to do that, Your Honor. That's a very important question. I'll come back to it later. Mr. Machuca, Flow Sports has complained that Mr. Saylor allegedly flipped or was going to flip an NHSCA contract. That's one of its complaints in this case, right?
Correct.
But in fact, that contract remains at Flow Sports. It has not been terminated or altered, and Flow Sports has suffered no damage as a result of that. True?
True.
Last week, when Ms. Burgess asked you about the technique videos on Mr. Saylor's Mat Scout channel, you are not suggesting to the court in any way, are you, that any video, technique or otherwise, has been posted by Mr. Saylor after the court granted the injunction, are you?
I thought Mr. Saylor had just refrained from doing the FRL show. I thought I had seen other type of video content.
I want to be real clear. Is it,
Yes, sir.
are you taking the position that Mr. Saylor has posted video content on his website, including technique videos, since the injunction has been in place?
I thought he had posted video content since the injunction.
Okay. Were you here or aware of a 2-day contempt hearing we had?
I was aware. I don't recall anything out of it.
And are you aware that Flow Sports presented no evidence of any video being posted after the injunction was in place at that time?
No, I'm sorry. I'm not aware.
Are you aware of anything that's happened since that time regarding the posting of video by Mr. Saylor?
Your question confused me. You said
Okay.
Since the contempt.
Yeah, I mean, you put up these videos that he put up in November of 2019, and we're suggesting to the court that he may have done this more recently. Is that what you were trying to do, or were you just saying that those had gone up and that happened to have been in November of 2019?
I didn't know that I called out when they went up. I thought I was just speaking to what they were.
Okay, but are you in a position to say that Mr. Saylor has posted anything after the injunction was in place that would be a video or a training video, as you call it, or a technique video?
Mr. Sotero, all I've seen is content come out. I can't recall specifically.
Okay, I want to ask about Mr. Saylor's counterclaims. The board took self-help and took away his stock options January this year, right?
Correct.
It based its decision because it believed that Mr. Saylor had committed some sort of improper conduct or something. Is that right?
True.
Are you aware of Flow Sports ever taking away somebody's stock options in a situation like this before?
No, it's really unique.
Right. Not for making improper or misleading statements in court, right?
I'm going to object as argumentative. I think he's implying that my client lied in court, and that's absolutely not true.
Clearly, I will determine all of this, right? So can we just get to facts and evidence that I don't know about, as opposed to fussing about things that aren't going to be helpful to that process?
Yes, Your Honor. So that stock option, which was part of Mr. Saylor's compensation, has been taken away from him by that action. And as you mentioned, you're unaware of that ever happening before, right?
Correct.
Okay. Your Honor, at this point, I have some more things I want to go over, but I really want to go back to the two issues that one that had to be done in chambers and the second that needed to come back. And so I would request that we go to that or allow me to pass and come back and address it over the lunch hour, whatever's more
Well,
convenient for the court.
Here's what I would say. We're going to start up again at 1 o'clock if we are finished with all these other preliminary matters, but I need to give my staff a break and I need to give all of you a comfort break and time to nourish and thus so forth. So why don't we come back at about 12:45? That'll give Ms. Burgess an opportunity to go find whatever part of the video or whatever she wants to find with regard to optional completeness. I would ask that you all confer about those things before you start arguing to me about them. So have a conversation and let's all get on the same page about that. And let's just recess until about 12:45. I will do my best to at least skim the brief on these other matters during the break. And that'll give Mr. Soltero time to at least skim it, if not completely digest it. Yes, sir.
And Your Honor, may I submit some material since this brief came in while I was examining the witness?
I don't know that it came in while you were examining the witness, but I don't know that you'd seen it before you started examining the witness. I haven't either, but you can submit whatever you want if necessary. Let me suggest that it might not be necessary, right? So I don't want you to spend a lot of time responding to things that you don't need to respond to. It's in the nature of an objection. I'm going to sustain it or overrule it. I don't know that you need to brief that. So up to you as to whether or not you want to submit anything. To the extent that you're asking for legal advice, I can't give it to you. If you want to submit it, submit it. You want to file something, file something. I think that we should have it all figured out in 45 minutes. So I'll see you back at 1:45.
Yes, Your Honor.
We'll be in recess until then.
Hey, Carlos?
Yes.
Can you put us in a breakout room, please?
Can you send me that page and line again, please?
Sure.